was older than 6 months.
Were you attempting to withdraw money from that account?
Well, I was attempting to gain ability to,
For what purpose?
in case the bail was set, I could bail her out.
Pass the witness, Your Honor.
Anything further?
Yes, Your Honor. Stephen, do you have phones in your home?
Yeah, cell phones.
Cell phones that you
Mhm.
have in your home. Do you also have internet access?
Yes.
So if a GPS monitor was put on your mom, she would be able, and it used internet access, you would have access to that.
Yes.
Is that right?
Mm-hmm.
Now, the state has asked you questions about community property. Do you know how long Tonya has been married again to Fred?
No, I mean, I really don't know. It was more than 2 years, I believe.
Okay. So probably, if I were to say 4 years, does that sound about right? They've been married?
Yeah, that's about right.
Okay. So in your understanding of how community property works, once you're married, you only get community property that was acquired during that time span, correct? It doesn't go back to the time that you were married before, is that right?
Yes.
Okay, so any limits to community property would be just since her last time she was married to Fred, is that right?
Yes.
Okay. And is it something that she can just go and say, hey, give me my community property? Or does she have to hire an attorney and go through that process?
Had to go through the process.
Okay, and how long could that take?
Now and then would be a long time.
Okay. And in the meantime, if the bond is set at $1 million and she's trying to get access to that, to that community property, she'd be sitting in jail waiting for that, correct?
Yes, very
As
long
it
time.
stands right now, while she is in jail right now, can you describe her ability to access funds as anything other than being indigent?
Yeah, it's zero. You can't access any.
Okay. So she would have to depend on either going to court and getting some money through a community property settlement, is that right?
Yes.
And that would be property that was acquired within the last 4 years or so, is that
Yes.
correct? Or she would have to wait on the mercy of her spouse, correct?
Yes.
Do we know if he's going to spend any money on her?
No, he was fairly adamant he was not.
And the money that she did have in the account, the 100 and so thousand that has now been frozen by the government, was that from a sale of her house?
Yes.
Is that correct?
Yes.
Pass the witness.
Anything further?
You mentioned earlier that she did not own the truck she was driving.
Yes.
Who did own that truck?
Cleveland Sheet Metal owns the truck.
That's a truck. That's the property, the company that is owned by Fred Couch, correct?
Yes.
But they were separated at the time she's driving around in that truck, right? Yes.
Yes.
Do you know who's been footing the bill so far for legal representation?
Me so far, for every little bit I could.
Okay. And nobody else that you're aware of?
Nobody else.
All right. That's all I have, Your Honor.
Ms. Patton, anything?
Since we're going to bring up attorney's fees, Judge, have you paid us anything?
Nothing.
Has Tonya paid us anything?
Nothing.
Are you aware of anyone paying us anything?
Nothing.
Pass the witness.
That's
Anything
all I have,
further?
Your Honor.
All right, I have a few questions, Ms. Smith-Willis. You mentioned to the lawyers that your mother had no property, no real property, is that correct?
Yes, sir.
And I think you also said that her bank account was locked out by the
Yeah.
government.
Yeah,
Do you know
locked.
which government it is?
No, nobody could give me any information.
All right. Do you know or have any knowledge whether your mother has any stocks?
No, she does not. As
What
far as
about-
I'm aware.
What about bonds?
Not that I'm aware of.
What about annuities?
Not that I'm aware of.
What about inheritance? Did she inherit any money from you?
No, no inheritance.
So your testimony under oath is that there is nothing.
There's literally nothing.
All right. And that the truck that she drove to Mexico would belong to, I guess, Mr. Couch.
Yeah,
his
his company,
Is that
yes.
correct? All right. Tell me about, you live where?
Right off 35 in Fort Worth.
You still in Tarrant County, or are you
Yes,
in a
it's-
different county?
It's Tarrant County, Burleson School, so it's right on the line,
Okay.
but it is Tarrant County.
All right. And do you know if your mother has any community ties to this area? And if there are, what are they? Nobody's told me that yet.
I didn't understand what you were saying.
She's a part of this community.
Yes.
Does she have friends here?
No, well, yes and no. Not in Tarrant County, I don't believe.
Does she have any other relatives here?
Not in Tarrant County.
Are you the only relative
In Tarrant, yes.
in Tarrant? Where are the other relatives located?
One's in Johnson, and the rest are in another city.
All right. Do you know whether your mother goes to church here?
Not that she used to, but I don't know where. I don't know if it's in Tarrant County. I
All
don't know.
right. And you told me that she does not work.
No,
Is that
she does
correct?
not. No.
Can she work if she's on bond?
She could. I think she'd have to, as far as I know, renew her license, as far as I know.
All right. That brings up another question. If she was placed on bond, since she does not own a vehicle at this time, how would she get around?
Well, we'd have to somehow get her a vehicle.
And would you be willing to do that?
Well, I have 2 vehicles. I couldn't lend one until we can somehow get her something.
All right. Because if she was on bond, of course, she would have to make appearances before the probation department. You understand that?
Yes, sir.
All right, I think that's all I have. Any other questions?
Just a few, but, she has another daughter.
Yes,
Okay, so she's got 3 children, correct?
yes.
And they, so that's you, who lives in Tarrant County,
Mhm.
and Christy, who lives in Johnson County, correct?
Correct.
And her current husband, soon-to-be ex-husband, lives in Johnson County? Or
No,
Tarrant County?
I think it's Tarrant County. It's Lake Worth. I'm not sure where it falls.
Okay. And her parents live in Paris, Texas?
Yes.
And when you said that her friends aren't in Tarrant County, did you mean that they're in Johnson County?
No, they may be in Tarrant. I'm not, it's north of Lake Worth, whatever county that falls into.
Okay. So that could be Parker County, I'm not
Yeah.
very good with
Yeah, I
directions, but
don't know.
contiguous counties to Tarrant County.
Yes.
And the license that she has, that you're aware of, the LBN, is that a license in Texas,
I believe so.
to work in Texas?
Yeah. I believe so, as far as I know.
And is it your understanding that when she was in California, that she waived extradition and voluntarily came back to Texas, is that right?
Yes.
And when she was in Mexico, she did not fight extradition back to the United States, isn't that correct?
Correct.
Her son did, but she did not.
Correct.
That's the witness.
No further questions.
All right, thank you, sir. You can step down. Next witness.
Your Honor, we rest as to the one issue that we're addressing today.
Very well. Thank you, Ms. Patton. Ms. Burt and Mr. Rousseau.
Your Honor, I will offer, I have one copy, I can show them to defense, or I can show them to you first, I guess it doesn't really matter. This will be stated as number 1, it's warrant for the arrest issued by a magistrate of Tarrant County. The second page is showing that she's in custody in Los Angeles. Second is, next 3 are documents from the juvenile case. First, judgment for determinate and indeterminate sentencing without jury trial dated December 4th, 2013. The second, number 3, is order of probation for determinate sentencing under 53.042 4 is a progress report in the same case, and I apologize, it is 99049-J. It's from the 323rd District Court. First page is progress report. It's written to Judge Tim Minikos. The attachment to that is Tarrant County Juvenile Services Terms of Probation, with the original probation conditions pertaining to Ethan Couch.
Is that it?
There's one more, I'm sorry. Stage 5 are documents from Chase Bank dealing with the bank account.
Judge, as to exhibits number 1, we have no objection. As to exhibits number 2, 3, and 4, again, we object to the relevance of those. These have to do with Ethan Couch and his probation in Tarrant County. And as I stated again, while I did raise that in my writ of habeas corpus, the lack of probable cause, it's my understanding that we're not addressing the probable cause to arrest Tonya Couch, and we will address that at a later time. We haven't waived that, but I believe that those would be relevant only to determine whether there's probable cause to arrest her, and that is not the subject of this hearing. We're simply limited to the issue of a proper bond amount to ensure her appearance in court. So we would object to 2, 3, and 4 as being irrelevant. As to number 5, we have no objections.
All right, 1 and 5 will be admitted. I need a response for 2, 3, and 4, Mr. Rousseau.
Here they all are, Judge. I'm going to hold on to the middle 3 just for a moment. Well, I can give them to you. That's 1 and 5. Here are the 3 that they were objecting to.
Okay.
2, 3, and 4, Your Honor, are all records from the probation, the case that resulted in probation involving Ethan Couch. The reason that I'm offering those documents, Your Honor, is to show that the defendant was present in court. They all recite the fact that she was present in court, and meaning that she was fully aware of the terms of probation for Ethan Couch. And the last document is actually attached to number, I guess it's number 4, 2, 3, 4. Pages 3 and 4, maybe 5 of that document are the probation conditions that were ordered by the judge in that case, indicating and she signed the document. Her signature appears at the bottom. The reason I have offered these records is to show that she's fully aware of the conditions of probation that Ethan Couch was under. Knowing that, she still took him out of the country. Probation condition number 2 contains the rule: you are not to run away without you're not to leave the jurisdiction essentially without the permission of your probation officer. That did not happen. See, they left the jurisdiction without the permission of the probation officer, and that has a direct bearing. I'm not attempting to show probable cause. I realize we're reserving that for another day, but that has a direct bearing to her willingness and her ability to follow, to observe and comply with any bond conditions that you may set in this case. There's not a great deal of difference operationally between a bond condition and a condition of probation. The person who is subject to that condition for the person who's subject to that condition, they appear about the same. You have to live with those conditions. And she's shown a willingness to not only violate that bond, his probation, but to do it in a big way.
Your Honor, and I think we're putting the cart before the horse, Your Honor. That's the offense with which she's charged. However, there's been no evidence that that is what she did. Additionally, those orders don't say anything about her being under an obligation to stay in the country and not leave the country and not to run away. There's no obligation on her. The obligation is on Ethan Couch, not on her. We're here to determine what would be a sufficient bond to ensure her presence in court. Her presence in court, not Ethan Couch's presence in court.
Yes. All right, I'm going to overrule the objection and admit them for the limited purpose of, for what they are, the order of probation, the judgment for determination, sentence, and the progress report. All right.
Your Honor, we'll call Darren Gabbert.
Darren, where is he?
He has sat in the back.
Have a seat, Mr. Darren. You may proceed.
Please introduce yourself.
My name is Darren Gabbert.
What do you do for a living, sir?
I'm a criminal investigator with the Tarrant County District Attorney's Office.
And are you a licensed peace officer?
Yes, sir.
Were you, in that capacity, were you the primary district attorney's investigator, district attorney's office investigator in the original intoxication manslaughter case involving Ethan Couch that was heard in juvenile court?
Yes, I was.
And are you familiar with that entire case?
Yes, sir.
And are you also familiar with the facts involving this case that has been filed against Tonya Couch, Ethan Couch's mother?
Yes, sir.
And I may have put the cart before the horse a little bit. Are you familiar with who Tonya Couch is?
Yes, sir, I am.
Who is she exactly?
She is Ethan Couch's biological mother.
Okay, and is she married?
Yes, yes, sir.
To whom?
Fred Couch.
And you see her present here in court.
Yes, I do.
Could you point out and describe something that she's wearing, please?
She's sitting at the defense table on the middle chair with a black dress on.
May the record reflect that the witness has identified the defendant, Your Honor.
Record will reflect.
How would you characterize the Couch family's financial condition?
My best recollection was they were fairly wealthy from their own business, a sheet metal business.
Are you familiar with the location? Let me ask it another way. Do you know where Tonya and Ethan Couch were arrested and when?
Yes, sir.
Where was that and when?
If I'm not mistaken, the date was December 28th, but it was in Port of Arten in Mexico.
Have you interviewed people with first-hand knowledge of any arrangements that were made regarding the use of our, well, I'll pass on that. Come back to that maybe. And did you monitor the, or were you in contact with, during the time that the investigation regarding their whereabouts was going on, were you in contact with other law enforcement officials who were trying to track them down?
Yes, sir.
I'll pass the witness, Your Honor.
Thank you. Investigator Gabbert?
Yes, ma'am.
Hi, I'm Stephanie Pratt. I'm going to ask you some questions. Is that okay?
Sure.
So if you don't understand something, just let me know, and I'll try to rephrase it.
Okay.
Okay, thank you. So you stated that Tonya and Ethan went to Mexico, and the reason was to avoid Ethan's reporting to probation officers. Is that correct?
Yes, ma'am.
That's what you stated, right?
Yes, ma'am.
Okay. Who gave you that information?
I can't recall exactly who gave me the information firsthand. It was was developed through our investigation. As I spoke to witnesses that were, at the time I didn't know they were at the going away get together, but later learned that they were. I don't know if that's making a lot of sense, but it all kind of ran into one.
Objection, sidebar.
You stated that, let's go back and go step by step, because to me it's really fuzzy. You state affirmatively that the reason was to avoid Ethan reporting to his probation officers. Why do you say that? Who told you that?
It was the development through the investigation that the reason that they had left was to avoid reporting to their probation officer.
So it was developed through the investigation. Do you
Yes,
not
ma'am.
recall who told you that?
Some of it was surmised upon my own getting together all the information. I mean,
Okay, so you drew the conclusion that it was to avoid Ethan reporting to his probation officers.
solely,
Is it part of it?
yes, that's part of it. Yes,
Was your
ma'am.
conclusion? And you made that conclusion based on what?
Well, I don't have all my notes with me. I'm sorry. Interviews with witnesses. In particular, the one witness that gave us the most information about was Garrett Ballard.
Okay. So when you use the statement that it was developed in your investigation and you're not sure who the witnesses are who told you that, is there any way that I can verify that the information that was given to you was credible?
I didn't say I wasn't sure who the witnesses were. Sorry.
Okay. But you don't remember right now?
I know who some of the people I talked to were.
Okay. Who specifically gave you the information that the reason was to avoid Ethan reporting to his probation officers?
Like I said, that was Garrett Ballard.
Garrett Ballard told you that.
Yes, ma'am.
What else did he tell you?
It was a long meeting. I can
Okay.
get my report.
He told you that they left to avoid him reporting to his probation officers.
It was his last chance, and he kind of left it open-ended to leave the country,
Okay.
just to go to Mexico.
And it was to avoid meeting his probation officers on what date?
I don't know what day he was supposed to be there.
He had a meeting with the probation officer on December 3rd, correct?
Right.
And he made that meeting.
He did.
correct? The arrest warrant affidavit says that he didn't make the meeting. Are you aware of that?
No.
So December 3rd wouldn't be one of the days that he was trying to avoid meeting his probation officers, correct? Because he made that meeting, right?
I don't know. I don't know when he was supposed to come back.
So you don't know when the next time that he was supposed to meet his probation officer?
No, I don't have that information with me.
And you mentioned something about a going away meeting, and I think that the sheriff has made a big deal about a going away party. What is that referring to?
Talking about several people met up prior to them leaving the country.
What date?
I don't know, I wasn't there.
Okay, you don't, but I'm sure you asked the person who was giving you that information what date that was.
Well, they weren't exactly sure if it was the 3rd or the 4th of December, so I don't want to...
Okay, so who told you that it was the 3rd or 4th of December?
And that came from Garrett Ballard as well.
He said that they met up on the 3rd or 4th of December?
Yes, ma'am.
Okay, and tell me about that. Who was present?
He gave several names. Tonya was there. Ethan was there. Garrett was there. A guy by the name of Matthew Martinez was there.
And it's been characterized just now by you and also by Sheriff D. Anderson as being a going away party.
I didn't say that.
So you said going away, what'd you call it?
I said they got together before they left the country.
So you didn't
There was
characterize
a
it
meeting.
as a going away party?
No, I didn't.
And after speaking in your investigation, would you characterize it as a going away party?
I wasn't there.
Okay. But would you use that, would you characterize it as that? based
No,
on-
ma'am.
Okay. So it wasn't a going away party?
I don't know.
Well, what do you know?
I think it was a planning meeting.
Okay, So you think that it was a planning meeting, and who was doing the planning?
The people that were at the meeting.
So that was Matthew, Garrett.
Well, there was more. You didn't let me finish. There were several people
I'm
there.
sorry, go ahead.
Okay, there was Matthew Martinez, there was Braxton Faust was there. There was a couple of girls that were there that Garrett didn't know the last names and wasn't real sure about the first names. And not through Garrett, but I heard there was some other people there as well.
So, who else gave you information about this planning meeting?
The most detail was Garrett.
And you characterize it as a planning meeting. What happened at that meeting?
They planned on, as I understand it, again, I wasn't there, discussions that were taking place about how much money you'd need to take with you, how to get money, the fact that you couldn't get but so much money at a time from the bank.
And who was making those statements
At the meeting or to me, I'm sorry?
at the meeting?
I know there were several different discussions. There was one specifically that he told us about in the hallway of the house between just Garrett and Tonya. There was other discussions taking place among the group. So I can't tell you which meeting was which.
Okay. And you're saying at this meeting, it was discussed how to leave the country? Was it also discussed where they were going to go?
Yes, ma'am.
And where did Garrett say that they were going to go?
Just generically Mexico, no place specific that I heard.
And what day were they going to go?
I have no idea when they were going to go.
What date did you have this conversation with Garrett?
I'd have to look at a calendar. It was last week.
It was the last...
It was last week.
Last week?
Mm-hmm.
Okay. So in January you had this conversation with Garrett?
Yes, ma'am.
So it was, you had this conversation, and then did you relay that information to A. Wright, the sergeant who swore out the arrest warrant affidavit?
No.
You didn't?
No.
So last week would have been January, correct?
Yes, ma'am.
That Garrett gave you that information?
Yes, ma'am.
You had not spoken to him before then?
No. I had tried.
Okay. And the handing off of identifying information, what is that? What do you mean by that?
We had gotten information from Garrett's attorney,
Who is Garrett's attorney?
Harold Johnson.
Why does he have an attorney?
I don't know.
I mean, is he charged with anything?
No, ma'am. He would represent him from 2.5 years ago. He just same one.
Okay. 2.5 years ago for what?
Again, I don't know why he had an attorney. He wasn't any trouble then either.
Okay. Continue.
Okay, he had called our office and said that he was in possession of a driver's license and a credit card belonging to Ethan Couch, and he had received it from Garrett Ballard.
Okay, so Harry called you and said that he had a driver's license and a credit card that belonged to Ethan?
That's correct.
So how does that help Ethan leave the country? Ethan's driver's license and credit card.
Right. And the second part of that story is that Garrett Ballard did not have his identification any longer.
Okay. Was any identification given to Tonya Couch for her?
I have no information on that.
Any allegation that Tonya Couch changed, you saw Tonya when she got into custody in Mexico, right?
Mm-hmm.
Has she changed
Yes,
her
ma'am.
appearance in any way?
Not that I can really tell.
Her hair was the same color?
It was a little shorter.
Shorter?
Looked like maybe. Well, I saw her again 2 years ago. Was the last time I saw her.
So she still has, and you would agree that she has very distinctive color hair, correct?
Red hair, yes,
You're
ma'am.
not going to miss that, right?
If you're looking for it, you know.
You're not, right?
Sure.
And it's curly.
Mhm.
Didn't change that when she was in Mexico, to your knowledge.
No, ma'am.
Didn't do anything to change her appearance, correct?
No, ma'am.
Wearing a hat, you've seen pictures of her wearing a hat, trying to hide her identity, her physical identity.
Not that I saw.
Okay. And you've seen a lot, you've been following this case, right?
Yes, ma'am.
And it's your understanding that when she was in Mexico, she did not fight extradition back to the United States, correct?
I don't believe she did.
Okay. Ethan did. You believe he did, right?
Yes, ma'am.
She did not, correct?
Depends on if you want to read the news reports or not, ma'am. I'm sorry.
From what in your investigation, you have gotten no indication that she fought extradition to the United States.
I heard she filed some paperwork that wasn't correct or wasn't signed correctly or whatever. Whether that's true or not, I can't testify to that.
So you have no basis to conclude that she fought extradition.
No, ma'am.
And she clearly didn't fight extradition from California to Texas, correct?
No, ma'am.
Additionally, when Ethan was placed on probation, was Tonya under any court orders at that time?
I wasn't privy to any information like that. I mean, she wasn't in any trouble.
Okay. She wasn't under any court orders to remain in the country in December, correct?
Not that I'm aware of.
She was not on bond requiring her to remain in the country in December, correct?
Not that I'm aware of.
There was no directive from any court saying she had to remain in the country in December, correct?
I have no knowledge of that.
So juvenile court did not give her an order saying she was not to leave the country, the county, or anything like that.
No, ma'am.
And at the time that Garrett says that this conversation to avoid Ethan's probation officers, that occurred on, Garrett said it occurred on December 3rd or December 4th, is that correct?
Yes, ma'am.
At that time, there was no directive to apprehend Ethan Couch, is that correct?
I don't believe that came out till later on.
Right. That didn't come out till December 11th, correct?
Right.
And at that time, there was no motion to revoke Ethan Couch's probation, correct?
No. I don't know if there was any paperwork filed or not. I don't know.
And I'm not talking about transferring his probation, I'm talking about revoking his probation.
Right. That'd be a question for the probation office. I have no idea.
As far as you know, as December 3rd or December 4th, when this conversation supposedly took place, there was no revocation of probation petition filed against Ethan Couch, correct?
I don't know.
Okay. And at that time that conversation was supposed to have happened on December 3rd or December 4th, Ethan Couch had not yet missed a meeting with his probation officer, correct?
I wouldn't have that information.
Okay. Are you aware of it? Of whether he missed his probation appointment as of December 3rd or December 4th?
No, ma'am.
When is it that your belief that Tonya Couch went to Mexico? What
Sometime
day?
after the 4th.
Sometime after the 4th?
Is my opinion. Again, I don't know.
Okay, and that's based on what?
Based on the fact that nobody could get a hold of them, or I say nobody, from what I understand, the probation officer could not get a hold of them after the call to her to bring Ethan in for a urine analysis.
Okay, but that call was on December 3rd,
Okay?
and they went that day.
Okay, as I understand it, he was supposed to come back.
On another
This-
date?
The story that was told to me from Garrett was that he didn't want to go because they told him to go to the detention, or the juvenile detention area, and he felt like because, and this is third party, it's Ethan talking to Garrett, saying because the location that he was supposed to report to was different, he felt like he was going to be taken into custody.
But the fact of the matter, what actually happened is he did report on December 3rd, and he did So Garrett's story saying that he was scared to do it, I mean, he did
Objection,
it.
Your Honor, it's argumentative, and it's irrelevant.
No, okay, that's fine, that's more.
And you are, have I already asked you that, whether there were any, Tonya Couch has any prior convictions that you're aware of? Isn't that correct?
I gotta look at my notes. I know there's been some encounters with law enforcement.
But she has no convictions.
Yeah, we're going to call Floyd Owens, Sergeant Floyd Owens.
Very well.
Have a seat, Sergeant Warren. Tell us your full name, please.
Floyd Owens?
All right. Mr. Rousseau.
All right, thank you, sir. Thank you, Judge. You are Sergeant Floyd Owens, is that correct?
Correct.
Is there a name you're more commonly known by?
Rusty?
Thanks, sir. I wanted to talk to you today about some costs that the Sheriff's Department incurred in connection with the extradition of Tonya Couch. Are you familiar with those costs?
Yes, sir.
Okay. In fact, were you asked to compile basically do an accounting to come up with a figure of the overall cost associated with that?
Yes, sir.
And what was, do you have a summary there in front of you that you can refer to easily?
Yes, sir.
And are these figures that we're about to talk about all backed up by documentation that you have if necessary?
Yes, sir.
What was the cost incurred by the county for hotel expenses for the deputies that were sent to pick her up?
$363.30.
And what were they had to go pick her up where?
Los Angeles, California.
And is there a per diem cost per each deputy?
Yes.
And, well, what did that total out to be?
Totaled 120.
And what was their airfare?
$1,035.50.
And did they rent a car?
Yes.
And did you also, does the county also owe them for their mileage?
Yes.
And what was that amount?
$29.33.
Now, was there an additional security detailed out to bring her safely to Tarrant County Jail?
Yes, sir.
And were there costs associated with that?
It was $496.48.
And altogether, what does that add up to, sir?
$3,177.97.
Thank you very much. I'll pass the witness, Your Honor.
Mr. Gordon.
Thank you, Howard. Mr. Owens, the total was almost $200, $3,200.
But yeah, $3,177.97, sir.
And Sergeant, you're familiar with the process when someone gets arrested. Let's say, for example, that someone is wanted in the state of Texas, out of Tarrant County, and they're in another state.
Yeah.
There are various ways that someone can be brought back if they waive extradition, isn't that right?
Yes,
One of the ways is to essentially put them on a bus. right?
correct.
And would you say that a bus is cheaper?
It could have been.
Okay. You certainly wouldn't, and the bus is a secure bus. I mean, this is not a situation where someone is told, here's a couple $100, make sure you go back to Texas, right?
Yes,
All right, so they're transferred securely. It takes more time,
yes, it does.
it does, but they get there and they get there cheaper, right?
Yes,
And also, it would also be cheaper because since it's a secure bus, you don't have to send deputies from this jurisdiction to escort them here. Isn't that right?
yes,
All right. And as a matter of fact, with the lion's share of cases and situations where people are being brought back from a different state to this jurisdiction, a great majority of those are done just in that way, right?
yes.
All right. How many times has somebody in the past year, how many times has somebody been flown back here at taxpayers' expense?
We make quite a few flights.
Okay. Quite a few, meaning how many?
You know, I don't have that figure in front of me, but I can guarantee that we do at least 15, 20.
15 to 20? And how many, in relation to how many people that are just driven by bus, brought back? Secure bus?
A few hundred.
Okay. So the great majority are brought by bus?
Correct.
Because it's cheaper.
Correct.
And very often, it may often also depend on the kind of charge that we're talking about, isn't that right?
It can depend on the charge, can depend on many circumstances.
Well, certainly. Would you say it's more likely or less likely that somebody charged with, let's say, for example, something like auto theft, more likely that they're going to be put on the bus, right?
It can be.
I don't want to put words in your mouth. Is it more likely or not that somebody charged with a lesser or nonviolent offense be put on the bus if they were found or apprehended out of state?
It depends on the circumstances.
Okay.
In what I mean by that, are they federal custody, are they, where are they at?
Yeah.
Are they medical? What do I have?
Yeah. You have to take in special circumstances, whether they needed health care or whether they had other charges in different jurisdictions. That's one of the things.
Sure, absolutely.
But assuming that, for my hypothetical, the charge is originating out of here in Tarrant County, if it's more likely that if somebody were charged with a major offense, that they would be extradited quicker than somebody charged with a lower grade felony, isn't that right?
As soon as we get our paperwork, we do the transport.
Exactly. And certainly the expenses in this situation were borne because of the decision made to bring her back by plane. Is that right?
Correct.
No further questions.
Very well. Anything further, Mr. Rousseau?
No, sir.
Thank you, Sergeant. Next witness.
Now we'll call Lisa Hunt.
Lisa Hunt.
She's
Ms. Hunt? Mr. Rousseau.
Thank you. You are Lisa Hunt, is that correct?
Yes.
Ms. Hunt, what do you do for a living?
I work as a probation officer for Tarrant County.
Do you have a specific assignment within the probation department?
I am. I'm the GPS officer.
And I said the probation department, what are y'all actually known as? What's the name of your department?
Community Supervision and Corrections Department.
Easier to say probation, correct?
Correct.
And you said that you are what was your specific assignment?
GPS or electronic monitoring.
Is there a unit known as bond caseload, or a group of cases that are assigned to something called bond caseload?
There is.
What is bond caseload?
In general, they're pretrial cases that are people who bond out while awaiting the outcome of their case.
Okay, but that's pretty much true of all cases that people make bond on. Is there a particular group of cases that, or a particular type of case perhaps, that a judge says that this person needs to have additional scrutiny, and they're put on something called bond caseload?
Yes, they're expected to report.
Okay. More frequently, or more frequently than somebody else, than a typical person on bond would be?
It just depends on the case, the court that the case is out of.
And are there a certain group of probation officers who are assigned specifically to handle the bond, supervise the people on bond caseload?
Yes.
And how many supervisors are there? How many bond caseload supervisors are
There are 5 officers assigned to the bond unit.
there? And how many of those, how many people do they supervise?
Approximately 800.
My math's not all that great, but something less, a little less than 200 per. What about, is one of those supervisors assigned to a particular type of person who is on bond? Let me ask it another way. People who have pending probation revocations, are one of those bond caseload officers assigned strictly to them?
Correct.
Okay. So you have, and the other 4 handle people with active pending cases, correct?
Pretrial cases.
Pretrial versus people who are already on probation, correct?
Correct.
Okay, gotcha. And you said the total number of people being supervised is about 800.
Approximately.
Is there anything that sounds like a pretty heavy caseload? What are you able to, do they go out, your probation officers actually go out physically and observe these people where they live or where they work or anything like that?
No.
Okay. How do they come in contact with these people? How do the probation officers come in contact with the people they're supervising?
Initially or?
Initially and later.
Initially, they're released from Tarrant County Jail to CSCD, or Community Supervision Department, and we do an intake and let them know how often they need to report all their conditions, and then they're rescheduled. And usually, depending on the type of case, they can report. We have a non-reporting caseload that is basically set up on a UA call-in system. And those are for
What?
a UA call-in system, and those are usually drug cases.
Okay.
And then we have other cases that are set up, they can report anytime, where from once a month to weekly.
And who decides that?
How often they're reporting?
Yes.
Usually the court.
Someone like Judge Summit.
Absolutely.
Is there any type of electronic monitoring that can be done to give us a little more certainty about where these people are at any given time?
Yes.
Tell us how that works.
On occasion, defendants or probationers, depending on their case, are placed on a GPS or electronic monitoring caseload. I handle those, and they report to me from Tarrant County Jail, just like any other pretrial cases. We affix a GPS monitor to their leg prior to leaving. Everyone that reports to me reports twice a month, unless the judge specifies that he wants them to report more often. And the monitor allows me to know their whereabouts 24 hours a day.
How many people are currently under electronic monitoring?
I currently am supervising 67 people.
And You said you can know where they are 24 hours a day. Obviously, you don't watch a computer screen 24 hours a day, correct?
Correct.
So how do you monitor people 24 hours a day?
We have a monitoring company that monitors it, and then myself, or we have officers that are on call after hours that receive the...
And if a person is, if an alert goes off, either and this monitoring company notices it, what happens then?
If the alert happens during business hours, I am watching the monitor as well as my monitoring company. So we immediately contact the defendant and ask them to clear the alert, whatever the alert is, whether they're in home violation or some other type of violation. And then we proceed. If we can't contact the defendant, then we will proceed to notify the court and request a warrant for their arrest, have their bond held insufficient.
And I may have already asked you this. If I did, I apologize. The type of electronics, did you say it's GPS?
Correct.
So there's no requirement that they have for example, a landline telephone in their home?
No.
I'll pass the witness, Your Honor.
Any questions from the defense?
Briefly, Your Honor.
Mr. Gordon?
Ms. Hunt, you said you supervised a number of people, is that right, about 67 was it?
Correct.
And they are all in varying degrees of cases, isn't that right?
Most of them are pretrial, but yes.
Pre-trial. So do you have murders on GPS?
Pretrial bond for murder, yes.
Do you have aggravated sexual assaulters on pre-trial?
Correct.
And you monitor those,
Yes.
obviously, right?
Yes.
Regular sexual assault cases?
Correct.
Aggravated assault cases?
Yes.
So there are certainly people that are on bond in this county that are on bond using the monitor with the idea that, well, you know, these cases, these guys, or sometimes gals, are on bond, but we want to take the extra step of making sure that we keep an extra eye on them. Is that right?
Yes.
And you are the person that is in charge of doing that.
I am.
And we're using the technology that's available to do a better job of keeping an eye on folks, isn't that right?
Yes.
And the monitors themselves, they're pretty sophisticated. Would you say that they're pretty sophisticated?
They use a GPS and cell phones combined, yes.
It used to be when years ago, when the technology came out, you used to have a landline, right?
Yes.
All right. So now we're able to have the cell phones because most people, they don't use landlines anymore.
Correct.
So would you say that the GPS, that the system that you monitor, it certainly made the people who are released on bond, gives the community a measure of security than they would normally?
I can't say that the GPS is going to give you security.
Well, if it's
monitoring.
It's monitoring. Would you say that it's a better situation that we have the technology and use it than not?
Yes.
Right? And in that sense, when you feel more secure that at least we have the technology, doesn't guarantee anything, right?
Oh, it absolutely doesn't guarantee anything,
Right.
correct.
But what I'm saying is, you know, if we have the technology available, at least it gives us some sense of security, or a little more than nothing.
Correct.
That's all I'm trying to say.
Yes.
Okay. In addition to the GPS monitoring, is it typical for you in your situations in dealing with these folks, they also have to report on a monthly basis, right?
At least twice a month.
Twice a month, okay. And they would also have to pay. It's not free, right?
No.
How much is it?
For the supervision piece
Yeah.
or the monitor?
The monitor?
The monitor's $300 a month.
$300 a month. Does that money go to the Is it the county that has the, is it the county that runs the system, or is there a private contractor that actually does the support for the systems, the components?
It's a third-party contract company.
Okay. And part of the fees that would be required if somebody were to be placed on a GPS monitor, obviously some of that goes to them.
The $300 a month is their fees.
Okay. So in addition to that, somebody has to report twice a month, as opposed to being on a regular bond caseload where they would have to only report once, right?
GPS people are not the only people that report twice a month, but I make all of my guys report at least twice a month.
Right. Again, for an extra measure of security, right?
Correct.
All right. No further questions, John.
Very well.
No more questions, Judge.
Thank you, ma'am.
Thank you.
Next witness.
Go right, Brian.
Very well. Anything else from the defense?
Just a minute, Your Honor.
All right. Very well. Both sides closed
We'll
in.
close, yes.
Arguments?
Who will vote?
All right. Ms. Patton?
Thank you, Your Honor. I'm sure this court has read the application for writ of habeas corpus that we have filed in this case, and I'm sure you've taken note of the arguments that I've made in there. I'm just going to, as I've said before, just address the one argument with regard to the bond amount, and we ask that it be lowered to $15,000, Your Honor. I have attached a bond schedule to the application, and that would state in a third-degree felony, the recommended bond amounts that Tarrant County usually follows is $2,500.
Now, Ms.
Obviously-
Patton,
Excuse me?
concerning the schedule,
Yes.
I think you'll notice that schedule is 15 years old.
It is, Your Honor, but I don't believe that it's been updated since then. I haven't been given notice of any other.
That's sort of why the courts and the judges pretty much decide what they want to do on it.
Okay, so you don't follow that?
I don't follow
No?
that.
Okay.
15-year-old schedule, no.
It was my understanding that it was still in effect, but I'll take that and we'll go back 15 years. It was $2,500. I think $2,500, even 15 years later, is not going to elevate to $1 million, Your Honor. And I know that in this county, people who've been accused of the most violent offenses don't even get their bonds set at $1 million. And as this court knows, the purpose of the bond, as stated in Article 17.15, is to give sufficiently, for it to be sufficiently high to give reasonable assurance that the undertaking will be complied with. And I believe $15,000 is sufficiently high, given that the testimony is that Ms. Couch is indigent. She doesn't have any money. She has no access to any money. While there was testimony that she is still married, that does not mean she has access to money. He would have to voluntarily give her money to make the bond, and there's been no testimony that he will voluntarily give her any money.
Now, it's my understanding, though, that she does have $100,000 in the bank, right?
That is frozen due to the district attorney freezing her money. So I don't know how the district attorney can come into court and on the one hand argue against lowering her bond, and on the other hand prevent her from accessing her funds and saying that she has all this money. They're saying she's got all this money, but they're not letting her access the money. So,
I'm certain you'll be able to take care of that, won't you?
well, I don't know, Judge. I hope so. So that's the situation that we're in right now. She doesn't have, as we speak right now, she's in jail with a bond that she's unable to make. And she has no prior convictions. She's lived in this county with her children at least 16 years. She has no prior convictions, no history of ever violating a court order that she was under, never violating any directive to appear in court that she was under. And the allegation with regard to Ethan Couch is simply, at this point, it's still an allegation, Your Honor. So it's a nonviolent offense, no prior convictions, no prior violations of orders to appear in court. She is, I think, another condition that, there are other conditions that you can put on her bond to ensure she appears in court, and I believe Your Honor is going to do that regardless, and she is willing to submit to a GPS and is happy to do that and report when needed, and report when ordered to report. The safety of the community does not have, there is no community allegations that the community is endangered by her actions. She has voluntarily returned from California to Texas. She did not contest her return from Mexico. So she is willing to submit to any other conditions. She just needs to be able to make the bond, and at this point she has no funds to make a $1 million bond, and we would ask that it be lowered to a reasonable amount that will ensure her appearance in court.
What's the status of her divorce? Because I would imagine she's going to get some money out of that too.
Well, she hasn't hired an attorney to represent her in that, and all I know is that the divorce is on file, it has been filed, and she has no access to any community property at this time. Nothing in her name, or her name and her husband's name. And I believe that the recent marriage is only a few years, so it's not like a 10 to 15-year marriage where she'd be entitled to community property for all that time. It's only going to be since she was married this last time.
Well, but even if
And I
she
don't
was just
know-
married 4 years, if you're talking about married to a millionaire, you still have a pretty
Well,
access.
and I don't know the income, Your Honor, of him, and I don't have access to his financial records.
You know whether there were any prenups?
Don't know that, Your Honor. Don't know if there were any property settlement agreements.
Well,
Don't
your
know
client is there, you want to ask her. I think she would know whether it's a prenup.
Well, Your Honor, I would ask that as it stands now, the evidence that's been in court is she does not have the funds to make.
Let me ask you this. Putting all that aside, the court has never been able to find out where this passport is. During the arraignment, your client told me that she thought the Mexican authorities had it. I asked the sheriff if during his processing of Ms. Couch that they had it, and he ascertained to me that they didn't have it. Can you tell me where that
We don't have
passport
any
is?
of her property, Your Honor. She was arrested and she had property in her possession and they took it from her and we don't know where it is. The important thing, Your Honor, is she doesn't have it.
Well, I want to make sure of that. I mean, you know, everybody's telling me that she doesn't have it, but nobody can tell me where it is. I know she did have one at one time.
Right, she did have one and I don't know where it is, Your Honor. And it's like proving a negative, Judge. We can't prove that we don't have it. All we can say is we don't have it. I don't know who has it. We'd like to know who has it. We'd like her property back, but we don't know where it is.
Well, of course, if you ask me to lower her bond, and I lower her bond, and she's gone because she's got her own passport, then I'd have a lot of concern about that.
Well, I have a lot of concern too, Judge. We don't have it. She doesn't have it. You can look at her property that was booked into the Tarrant County Jail. She doesn't have it.
All right. We'll see if we can find it.
Your Honor, I may have, I had intended to introduce this earlier. If the defense has no objection, I'll do it now. It's first amended original petition for divorce. Just cooperating with the date. It was filed in December.
What was that?
December, yes. The amended petition filed.
And then the actual petition was filed.
That was filed in August.
Right. So with that addition, with that statement that it was filed in August, the
Yes.
original petition.
Yes.
So, what is that?
This is, just to, you had asked about the status of the divorce.
Oh,
This is an amended petition that was filed December the 21st.
all right.
And
Exhibit 6 would be admitted.
Yeah, and I had intended to admit it earlier, but since Mr. McWilliams acknowledged that they were still married, that's the reason I chose not to.
Okay.
Your Honor,
And would you state also on the record that the original petition was filed prior to that?
Yes, the original petition was filed earlier than that. I have, but I will say this, Your Honor, the file, I reviewed the divorce file, and there's nothing there but the original petition. There was a notice that the suit was going to be dismissed unless they took it up and prosecuted it. And then that was filed on the 21st. And since then, on the 23rd, there was an amendment, a motion.
Incident to that divorce.
Well, one thing it does say, though, is that petitioner believes that petitioner and respondent will enter into an agreement for the division of their estate. If such an agreement is made, the petitioner requests the court to approve the agreement and divide the estate in a manner consistent with the agreement. So evidently there is going to be an agreement on the...
Well, that's from the petitioner's point of view. He has not been represented by counsel and has not filed an answer. So that's his opinion, but...
All right.
Your Honor, we're opposing the reduction of the bond in any amount, and I realize that it is higher than ordinarily, way higher than you would ordinarily get in a third-degree felony offense. But we're not dealing with a regular third-degree felony offense. Let me instead refer to the provisions of Article 17.15
Right.
from the procedure. And it lists a series of considerations that the court is to think about in setting the bond. Reasonable assurance of compliance. Well, we're dealing with a person here who has already shown a willingness to flee the jurisdiction. Now, granted, it was not on her own behalf, but she was helping another person flee the jurisdiction of a Tarrant County court. She was willing to expend great resources to do that. And we're not dealing with a person here who simply, in a Henry apprehension case, simply said, when the police come to the door, said, no, I haven't seen him, when he's actually hiding in the closet behind her. That's a typical hindering apprehension case. This is way different. This is a different species of hindering apprehension case. The allegation here is that she actually carted this person across the border, and we have evidence of a fair amount of preparation that went into that. And I think that has a direct bearing on her willingness and her ability to comply with any bonds, any conditions that you may set. And we know that we have shown that she's legally entitled to a fair amount of money out there. She's married to a man of great wealth. Now, I realize the situation is a bit murky, but she is still married to this man. He's quite wealthy, and even though they're separated, she's still driving a truck that's owned not by him, but by one of his companies. Regarding the ability to make bail, we don't really know. We've had a person sit up here and say that she doesn't have any money, but we know there's $100,000 in the account. And if you look at the bank records that I submitted, you'll see that on the day that she went in to withdraw the money, she was trying to withdraw $60,000. And she actually only got $30,000 cash. That $30,000 cash is completely unaccounted for right now. Regarding her work record, well, they say she doesn't work. No ties to the community. She has almost nobody living in Tarrant County. Her son lives in Tarrant County. She has a daughter in Johnson County, I believe, and that's about it. Her rest of her family lives in East Texas, so not terribly close. Length of her residency, well, Your Honor, according to the defense, she's essentially homeless. She's going to be living at the mercy of her son. I don't know that, I think we need a little more of a fixed address than that. Another condition that another consideration the courts are asked to look at is her previous compliance with bonds. Again, we don't have any evidence that she's ever violated a bond on her own, but she certainly helped her son violate conditions of his probation by taking him out of the country, not only out of the jurisdiction, but out of the country. In essence, Your Honor, we've got a well-financed suspect who's demonstrated a willingness to use her resources to evade law enforcement. She cut all ties with the outside world, and she headed for the border, and not only headed that way, but she made it. She got across the border, and it took a tremendous effort on the part of law enforcement to track her down. A $1 million bond is reasonable under these circumstances, absolutely reasonable under the circumstances. I don't think that anything else would get her attention. We request that the bond...
Because we're not here to get her attention.
As
I read...
To the extent... I'll try to cut you off, Judge.
Yeah, as I read 1715, and I'm going to read it verbatim for you. The amount of bail to be required in any case is to be regulated by the court in the exercise of the discretion by the Constitution and these following rules. The bail shall be sufficiently high to give reasonable assurance that the undertaking will be complied with. Basically, that she's going to show up at court when she's supposed to show up. The power to require bail is not to be so used as to make it an instrument of oppression.
Yes.
That concerns me with these high bails. The nature of the offense and the circumstances under which it was committed are to be considered. That's what I'm doing. This is a case that we're dealing with a hindering of this child. The next thing is the ability to make bail is to be regarded, and proof may be taken upon this point, which I think I've gotten. The future safety of a victim of the alleged offense in the community shall be considered. All right, and that's why I asked some of the questions I did about her contacts with the community, etc. But one of the things I am concerned about is that, you know, you can't set a bail just to keep somebody in jail. I mean, that's not what this Constitution or laws of this country is about.
I apologize, Ryan. I'm not trying to. When I said get her attention...
But I mean, $1 million, when you see that the woman doesn't have that, that would be to keep her in jail, don't you think?
If she really doesn't have it, perhaps.
And we're talking about a third-degree felony here. We're not talking about a capital murder. We're not talking about a murder. We're not talking about aggravated sexual assault. We are talking about a case that the punishment range is 2 to 10 years, not 2 to 20, not 5 to 99, not life. So let's look at it for what it is. I mean, I understand everybody's concerned. I understand that there possibly is outrage in the community and things of this nature, but as a judge, I got to look at the law, and I got to make my decisions based upon the law and that alone. So that was the whole purpose of this hearing. And I'll be very frank with you, I just don't believe everything that I've heard today, that it should be $1 million.
I understand that, Your Honor, and obviously, you know, we expect you to abide by the law. We know you're going to do that, but the law gives you quite a bit of leeway. And you are entitled to consider not only the level of the offense, but also any extenuating factors. And I think the fact that you are allowed to consider any aggravating factors, in fact, there's case law to back that up. And I've outlined what those aggravating factors are. This is not a standard third-degree felony. If it was, then $15,000 might make sense. But this is not a standard third-degree felony. This is a person that it took great efforts just to get back into the jurisdiction, to find in the first place and to get back into the jurisdiction. And we're merely asking for a bond that will ensure her attendance in court to answer for these charges.
Very well. Thank you, Mr.
And Your Honor, one more thing. In the event that the court, I'm assuming that the court, I know the court will set a bond, whether it's changed or not, but we would ask as conditions of bond that the cost of extradition of $3,177.97 be ordered to be paid as a condition of bond, that she also be ordered to surrender not only her passport, I realize there's some confusion about where that is, but we would also ask that she be ordered to surrender her driver's license. Because you can, under some circumstances, use just a driver's license to get into Mexico. Maybe not to get back into the United States, but to get into Mexico. And she's already shown a willingness to go there.
From my understanding, she doesn't even have that.
She doesn't,
She doesn't have anything. Okay. Real good. Thank you, Mr. Rousseau.
Thank you, Your Honor.
All right, the court has heard testimony concerning this bond reduction hearing. And after hearing testimony, the court's decision is this. I am going to lower bond for Ms. Couch to $75,000. I think that's an amount that is appropriate for this type of case, and the fact that I don't think it is oppressive. I think Ms. Couch can make that. If, in fact, she does make this bond, I'm going to have several conditions that I want, and I talked to Ms. Couch about this at the arraignment. I want her to report to the Community Supervision and Corrections Department of Tarrant County, Texas, immediately after she makes bond, and to continue to report as scheduled weekly. I want her weekly reporting. I want her to stay with her son at his Tarrant County address, and I want to have a good address and phone number for that home. I didn't ask for the address because I wanted to remain secretive for you, for everybody. I want her to abstain from the illegal use of controlled substances. There's been no allegation that she takes drugs, but I want to make sure that she doesn't, and she will be tested on that. So I want you to explain that to Ms. Couch. I don't want her to purchase, possess, or transport any firearms or weapons at all. My understanding that there was a weapon found in Mexico. I don't know whose weapon it was. There was no discussion and no testimony on it, but I don't want her with any weapons. She has to pay a $60 a month supervision fee while she's on bond to the Community Supervision and Corrections Department. She must fully participate in and comply with the rules and requirements of our probation department. Electronic monitoring program. I do want an electronic monitor, and I told you folks that I wanted that. If and she isn't to change her dress without prior knowledge to my probation department. So I want her at her son's home, and that's where I want her to stay. If there's anything that changes, I want to be made known of that. I don't want you to consume any alcoholic beverages, Ms. Couch. You're not to refuse a breath, blood, urine, or field sobriety test if requested by the court or my probation department. You are to submit and pay for non-dilute urine samples for testing for controlled substances, cannabinoids, as directed by my probation department. You are to avoid persons and places of harmful or disruptible character, meaning I don't want you around clubs and things of this nature. You're going to be kept really, really strict on the lock and key. And you are going to be released to my probation department once a bond is set on that. You are also to allow the probation department to visit you at home or elsewhere at any time. And we want to make sure that you follow all these rules and regulations that I'm going to sign into effect.
Your Honor, may I inquire, you said you want her to stay in that home. Are you ordering 24-hour home confinement?
At this time I am, and that's subject to be reviewed after I look at it for a while. All right? Now,
Your Honor, and
yes.
she gets time off the monitor, visit lawyers and doctors, is that correct?
Yes, she can do that. I also am going to order that she pays this Sheriff Department restitution of $31,7793 for going out there to pick her up and getting her back here. All right? That takes care of the bond reduction hearing. There's one other matter I want to put on the record, and that is going to enter into the record, and I'm giving copies of this order to the lawyers involved in this case, both the state as well as the defense. And this is an order regarding discovery and media dissemination. I have previously instructed counsel for the state and the defense that the Michael Morton Act shall apply to these proceedings for all matters involving discovery pursuant to Article 3914 of the Code of Criminal Procedure, and the parties are to make no extrajudicial statements or otherwise engage in conduct calculated to, in effect, try these proceedings in the media in violation of Rule 3.07 of the Texas Disciplinary Rules of Professional Conduct. The court believes it is best to memorize the same in writing, which I am doing. The parties, both sides, have agreed to the entry of this order, and accordingly is therefore ordered that the Michael Morton Act shall apply to these proceedings, in order that counsel for either party in this cause shall not make any extrajudicial statements that they expect to be disseminated by means of public communication. And I'm talking about, faxes, emails, Facebook, Twitter, and whatever else that we have. And I'm a little at a loss because I don't join any of that stuff. I don't know any of that. But I know that it's out here today. So I want you to stay away from that. And I find it amazing that people use that. I have people defendants that come in here and that's how they're caught, because they're on those things, right? Okay, anything else? Right? Public communications, the lawyer knows or reasonably should know that it will have a substantial likelihood of materiality prejudice in these proceedings, except as provided by Rule 3.07C of the Texas Disciplinary Rules of Professional Conduct. It is hereby further ordered that the lawyer shall not counsel or assist another person to make these statements. This order also applies equally to dissemination of any discovery exchanged by the parties which has not been formally admitted into evidence in these proceedings. That's going to be signed by me, Wayne O'Sullivan, Judge, Criminal District Court Number 2, on today's date, January 11th, 2016. All right, we're in recess, everybody.
Public Information Act, are you saying that if someone were to request documents related to the case under the Public Information Act?
I'm talking about the law.
Okay.
I don't want them talking.
Okay, because it sounds like the last sentence kind of applied to documents, and I want to make sure that's not an order saying that.
No, I don't think I said that.
Because it said discovery, and so to me discovery would be documents.
Well, discovery, when I'm talking about discovery, I'm talking about between lawyers. They're giving each other stuff. Right? And that's all I'm concerned with.
Okay.
Okay?
All right.
Not, freedom of information.
Okay. All right.
I don't want them talking about it.